Hi, my name is Josh Lawler. I am a partner here at the law firm of Zuber, Lawler, and Duca, practicing securities law and also working with distributed ledger technology. You might think of it as blockchain. I am here today to help you navigate the waters of an ICO, or TGE if you prefer. I am a lawyer, but I'm not rendering legal advice right now that anybody should be counting on. If you want to do an exchange offer or any kind of securities offer, really, you need to get competent counsel. So please do not take this as legal advice, and certainly do not take it as investment advice. Okay, with that said, first thing, let's state our goals here. Number one, you want to raise capital, and you want to distribute tokens. And ideally, you want to get liquidity for your investors relatively quickly. In 2017, you could do that all pretty easily because people just didn't bother with securities regulation, and that probably didn't work so well, to be honest. The SEC just released a whole bunch of subpoenas looking into things that took place in 2017, and you can kind of think as 2017 to tokens the way 1928 was to stocks. So we don't want to continue that, and the fact that you're watching this makes me think you want to stay within the bounds of the law. We have a lot of clever lawyers to blame for what I have to think is a pretty big red herring out there, and that is the distinction between a security token and a utility token. And the fact of the matter is that that distinction makes no sense. It's apples and oranges. In July of last year, the SEC in context of Ethereum and the DAO transaction, did what it usually does when it looks at whether something is a sale of securities. It applied a test called the Howey Test that is from a Supreme Court case in 1946 that says if you have an investment in a common enterprise based on the efforts of others with the expectation of a return, that you were talking about a transaction in securities. Okay, that's fine. So some lawyers said, well, okay, well, what if we don't have an investment? What if instead it's you're buying a utility? You're buying something you can use, like a ticket at an amusement park, for instance. That should work, right? Well, unfortunately, not so much. The fact of the matter is that the securities laws regulate transactions, not things like securities. So you can have a securities transaction that's regulated where you're buying stocks, bonds, tokens, whatever you want. The point is, if you're buying it with the investment intent that's described in Howey, then it's a security, and the fact that it has utility somehow just means it's a security that has utility. This has caused the chairman of the SEC, Jay Clayton, to say that he has yet to see an ICO that was not a sale of securities, and as mentioned, they seem to be ramping up enforcement efforts. So just assuming these things aren't securities, not a good idea. Where does that leave us? How can we do this? Well, there is something called an exchange offer. What exactly is an exchange offer? Well, what we're really doing here is we're doing an issuance using private placement exemptions, one that has been around for quite some time, in fact, to allow us to raise our capital so we can get going on what we need to do in terms of building and marketing our system, and also so that we can then fund our next sale of securities, which is going to be pursuant to Regulation A+, which is new, which came in with the Jobs Act. So before I get to that, let's talk about Regulation D and specifically 506C. This is the private placement exemption that everybody kind of knows and loves and has been around for decades. It allows you to raise unlimited amount of money, follow certain particular rules of conducting a private placement. Now, thanks to the Jobs Act, it's not even all that private anymore because now you can do something called general solicitation, which you used to not be able to do, and that has kind of freed things up. So you can take your tokens on the road and show them to all kinds of different investors, and that's just fine. Regulation D, unlimited amount of money. You sell to just accredited investors. Most of the investors in pre-sales are accredited investors, as it so happens, and it basically just means somebody who has a certain amount of money, and they're deemed to be sophisticated enough that they can watch out for themselves in any kind of a securities transaction. So you sell just to accredited investors, and you do not have to use any particular form of offering document, which is great because you can usually do something that's short and to the point and covers the salient information and discloses enough so that you won't commit fraud, but doesn't have to be a giant registration statement style document. And if you have a single unaccredited investor, it does, so that's actually a really important point. Now, the downside to Regulation D is that your purchaser is supposed to hold those securities for at least a year. I'm oversimplifying, but go with me on that for the moment. So what does that mean? Well, for one thing, they're not going to get that instantaneous liquidity that they've got in 2017 when 2 weeks later they'd be able to put this stuff on an exchange. That's probably a good thing, by the way. And secondly, you are not going to, through Regulation D, get your tokens out into the world in an unrestricted fashion so that somebody can actually use them in your system. Now, if you're selling a SAFT, that may not be a big deal because it may be a year anyways until you're distributing tokens that can be used. But even if that's the case, the other catch here is that you have trouble getting wide distribution right away because your accredited investor may decide they want to sell all those tokens in one big block. You can't really control that. So getting out to thousands or tens of thousands or hundreds of thousands of individual users with your token is not really likely to happen through a Reg D transaction. All right, so let's talk about Reg A Plus for a second. Regulation A Plus was put in with the Jobs Act. We're going to talk about Tier 2 of Regulation A Plus, and that allows you to raise up to $50 million in an offering in a one-year period. There's discussions in Congress to raise that to $75 million. Right now it's $50 million. And for Regulation A Plus, you do have to file a specific form of registration statement with the SEC. They're not going to comment on it substantively, but it has to be in a certain form, and that certain form requires audited financials and other types of disclosures that people are not used to making in ICOs. And it's because of that that we don't just jump right in and do the Reg A Plus offering. It takes a while and it's expensive, so you're better off doing that Reg D first. But one of the magical things about the Reg A Plus offering is that once you've sold your securities in a Reg A Plus offering, your tokens, they're now unrestricted securities. So anybody who bought outside of certain affiliates and other people of that nature can sell to anybody else on a secondary market. That might be an exchange, that might be within your token economy, however it may be. It could be a local Bitcoins type of thing where literally they just call up the guy next door and they meet on the corner at Starbucks and they sell securities and your tokens, and that's fine. That's Reg A Plus. Now, how do we put these things together? Why is it that Reg A Plus is going to be so beneficial for us particularly? Well, it's called an exchange offer. And it's something that I used to do 20 years ago when I was working with junk bonds. And the buyers of those bonds wanted to do it quickly so that Reg D was appropriate, but they then wanted those bonds to trade on an exchange, so they had to become unrestricted somehow. So what we did then, and what I'm proposing we do now, is you do your Reg A Plus offering, which is again filing a registration statement. But instead of selling all of the tokens being registered for cash, some of them you sell to get back the tokens that you sold in Reg D that are restricted. That means that your purchasers from your Reg D transaction can now have unrestricted tokens that they can then sell. So they got liquidity a heck of a lot faster than 1 year, or at least potentially they did so. And you can actually do your Reg A Plus offering more or less at the same time as your Reg D offering. The other thing about Reg A Plus and 506C offerings out of Reg D that's really cool, they preempt state law. That's really, really important. You may have heard of something called blue sky law. Every state has its own securities laws, and if you have to comply with all of them, which you would if you're doing kind of an unrestricted crowd sale style offering, it's going to be very expensive, very time consuming, very confusing to do that. So the fact that you've got federal preemption is really super important, and that is the exchange offer. I hope this has been helpful. Again, I'm Josh Lawler at Zuber, Lawler, and Duca, and be more than happy to speak with anybody about this. You can reach me by email at jlawler, that's the letter J, Lawler, @zuberlaw.com. Thank you.